We call the Coweta County Board of Commissioners meeting August 8, 2023, 6 p.m. Come to order. Please note that if anyone wishes to address the board, that they will be offered 3 minutes at the appropriate time based on meeting rules. Please be mindful of your time and to give others the opportunity to also address the board. We'll start off first with the Pledge of Allegiance and then the invocation with Commissioner McKenzie. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Let us pray. Our most gracious Heavenly Father, I come to you tonight to ask for your love, your joy, and your blessings as we submit ourselves to you as one of your servants in this county. We come asking for mercy and grace as we handle the issues that come before us tonight. Let us lift each other up and pray for wisdom and understanding in all things before us tonight. We ask these things in the precious and holy name of our Lord and Savior, Jesus Christ. Amen. Amen.
Thank you, Bill. Thank you, Bill. Mm-hmm. So notification of the rules. The rule governing the commission meetings are available on the county's website and on the table in the lobby located outside the meeting room doors. Now we'll enter regular session, and I'm going to combine 1 and 2. Request approval of minutes for the called meeting work session held July 25th, 2023. And number 2, request approval of the minutes for the regular meeting session held on July 25th of 2023.
Second.
Any discussion? All in favor?
Aye.
Carries unanimous. Are there any supplemental agendas to be added to the agenda from either you or the commissioners?
We do not have any, Mr. Chairman.
So we'll enter our public hearing. First item of the hearing is number 3, public hearing regarding new consumption distilled spirits beer and wine license filed by Ronak Patel in the operation of Old Chicago Pizza in Tarpon, located at 215 Fisher Crossing Drive, Sharpsburg, District 4. Ms.
Good
Joy.
evening. Mr. Patel has applied for the business license. It's a new, an alcohol license. It's a new structure. So he said the building would be built probably in the next 3 months. So he'll be within that 6-month time frame. All of his background checks came back. The distance survey came back, and he is here if you have any questions.
So 3 months. All right. This is the applicant. Does he wish to speak?
No, sir.
No? Okay. Any comments in support or in opposition of the proposed license?
There's no one signed to speak, Mr. Chairman, in support or opposition.
Okay. If there's no opposition or in favor, I'm going to call for a motion to close.
Motion close. Second.
Any discussion? All in favor?
Aye.
Carries unanimous. I'm going to make a motion to approve this alcohol license at the location.
Second.
Any discussion? All in favor?
Aye.
Aye. It carries unanimous. Item number 4, public hearing regarding a new packaged beer wine license filed by Kahaje Narudin in operation of Serve Best Food Mart located at the corner of Laura Smith Road and East Highway 34, Sharpsburg, 4th District. Ms. Thompson.
This one is kind of unique. They haven't closed on the property yet, so they're asking to go ahead and get the alcohol license approved for that location before they close on the property. The proposed distance survey meets the requirements per our ordinance. All the background checks and fingerprint checks have been done, and it meets the distance the GBI requirements. But the staff is going to propose some conditions on this one, that they supply us a copy of the deed after they close on the property, and that they give us a final scale drawing from a surveyor when the building is complete. And with the ordinance saying that they can only have 6 months to open, we're going to go ahead and extend that to 18 months to allow them to close and build on that property. And then before they can be issued the license, they'll have to have a CO and the final distance on it.
Okay. Does the applicant wish to speak?
No, sir.
Any comments in support or in opposition?
It appears in addition to the applicant, Mr. Chairman, Jim Motley's here. I don't know if he wishes to speak. Okay. That's all that's signed up in support
Okay,
or opposition.
so I just have a few questions from my perspective, since we're deviating from the 6-month
Okay.
to 18 months. So I have more of a question for Ms. White in her office, is that we have that condition about the 12-month window for the LDP and get things started, so that's not going to be a problem for them to comply with that?
No, sir. I mean, with the construction and all, they'd be ready to start. It's just a matter of the ownership and wanting to make sure everything's going to go good for an alcohol license.
Okay.
So that would not be a problem.
Okay. And then the other thing, just to let the board, my colleagues know, that I did ask the applicant, there are 3 churches that are very close in proximity to this location, and I did ask them to go out and meet with the church eldership, or whatever you want to call it, and I know that they were successful in reaching one. The other 2 they had contacted 3 times, and they showed me where they did that, so there was no feedback on that. So they meet the ordinance, just to let my colleagues know this. So at that, any other discussion?
What is the required distance that the store needs to be from the churches?
It's 300 feet from door to door.
So that's not an issue.
No, they're just going to have to place the store in a certain place for it to meet the distance requirements, but it's possible.
Okay, and then, did you say they don't have a lease? What is it that
They haven't even purchased the property yet. They didn't want to purchase the property until they knew that they could get the alcohol license, because the purpose was to put a convenience store there.
Okay. So that's a minor risk for the occupants or the owners of the store, and not for us.
Correct.
Does this set a precedent of any kind?
No, we've had to do this before. It's very rare. The county's not had a whole lot of new construction with alcohol license. It's been existing locations. But with the growth of the county, I can see this being something that's probably going to happen again.
Okay, thank you, Joy.
Any other questions? I'll make a motion to close the public hearing.
Second.
Any discussion? All in favor? Aye. Carries unanimous. And then I'm also going to make a motion regarding the proposed alcohol license to be approved based on the conditions of the deed being presented to community development after closing. You have to have your LDP started within 12 months. Otherwise, we have the opportunity to take it back to rezone. And again, just be compliant with the distance ordinance, and I'm sure you'll be surveyed on that. So,
Second.
any other discussion? All in favor? Aye. Carries unanimous. So now we're going regular session again. Public comment. Is there any comments for any items that on the agenda?
Mr. Chairman, we have a number tonight that signed up to speak both on the agenda and off the agenda. As you said, we'll start with items on the agenda. We do have more than 10 speakers signed up, so we'll start in order. Just a reminder, your rules do say.
I'm going to remind you before you come up and speak that there's a 10-speaker limit, and the most you can have is 3 minutes per speaker. So whoever is going to speak, just keep that in mind. Thank you.
So the first.
And another thing too, there'll be no outburst or yays or nays or hand clapping, because I'll have you asked to leave the room. Thank you.
So the first, Mr. Chairman, is Dan Zavada. I don't know if you want to speak on item number 5 or not. No.
Yes, we're here to my associate Josh Lawson.
Oh, I need your name and address, Mr.
Sorry, Dan Zavada, 44 Waterstone, Noonan, Georgia. We were here before you many times, I think, in regards to the liquor license. And obviously, we've had several delays with the DI from the state and the county and so forth. But our utilities are in, our landscape, our infrastructure is in. We're paving the roads and the parking lot, and we're ready to go up. But all this with the DRI is delayed us about a year. So we're ready to proceed, and we'd like the commissioners to think about granting us another year's option to complete the project. We're online. It's going to be a beautiful site and a beautiful store. And Josh, if you have anything to add to that, that's pretty much it. So we're here for the long haul.
Okay. Thanks for your time. Thanks for your
Thank you.
comments.
Next, Mr. Chairman, Melissa Griffiths.
Good evening, Melissa Griffiths, 32 South Court Square, Noonan, Georgia, 30263. I'm here tonight on behalf of Turnstone Group. They are item number 6 on your agenda, gentlemen. Their rezoning was approved on August the 9th of 2022 with condition number 13 that included a time limit when the permit had to be pulled. We're here tonight requesting an additional 4 months on that timeline. As most of you know, the seller of this property are numerous family members. And it took until April of 2023 to get through the probate process with the 6 to 7 family members so that they could actually get the property ready to sell, and we could not submit anything until that had occurred. So in April 2023, when they were released from probate court on April 18th, my client, so the buyer developer, was able to make its first application in the same month. Unfortunately, there were some title issues that also had to be addressed on the part of the seller with the closing attorney. So these things are outside of my client's control. But they have been actively working on civil and architectural plans since the approval last August of 2022. The extension, we don't believe, would adversely impact the citizens of Coweta County. We are asking for the 4 months. We hope we can get it done in less than the 4 months. They have already submitted and have comments back and have to make edits. I'm asking for 4, hoping that we don't have to come back again and ask for another 30 days if something happened. I do have Mr. Goldstein here with Turnstone Group if you all had any questions for him specifically, but we appreciate your consideration.
Thank you.
Thank you.
Next, Mr. Chairman, the applicant for item number 11, Catherine Malone. I don't know if she wishes to speak. Okay. Next, Mr. Chairman, we have George Hammond, applicant for item number 13.
George Hammond, 120 Macedonia Woods Drive in Noonan, and I am the applicant and the owner, and just wanted to reiterate our desire to build a carport, and we need a variance of 5 feet on the front building setback for that. And the reason for that is just to be able to protect my vehicle from weather or falling limbs or birds, etc. Thank you.
Thank you. Thank you.
Next, Mr. Chairman, Armand Very, the applicant for item number 7.
Only if needed.
Next, Mr. Chairman, Stephanie Davis, the applicant for item number 8. Okay. Next, we have Craig Jackson.
Good evening. Craig Jackson, 58 Fox Hollow Run, and I'm just here to speak in favor for the number 9 for the model homes. I think that was just a kind of got lost in translation there, but they'll speak to that. I wanted to say, when realtors show up, instead of driving all around a busy construction site with tractors, and it's easier to go in a model home park, and it just makes it safer and just makes a lot of common sense, and it keeps it all concise and nice and neat. So that's all I'll say. I'll let them finish up. Thanks.
Thank you.
Next, Mr. Chairman, Dustin Baker.
Hi, my name's Dustin Baker. I live at 5241 Hampton Ridge Drive in Flurry Branch, Georgia, 30542. I'm here on behalf of the applicant, Culture Homes. We're asking for clarification on the model home park ordinance, clarification on the interpretation of that ordinance. And we're here if you got any other questions tonight.
Thank you.
Next, Mr. Chairman, Sharon Baker.
Hi, my name is
is Sharon Baker. I live at 85 Primrose Pass, Noonan, Georgia, 30265. I am here about number 12 for and I ask that you take the recommendation of the zoning recommendation board in the denial of the variances that the Quick Trip is requesting, and that is to move the Quick Trip closer to the road and to allow them to have more parking in the back. We are very concerned about the growth and the overgrowth that is happening in our little corner, our little edge up there of Coweta County, and we just ask that you consider the best needs for Coweta County and the citizens that live there. I represent, of course, the HOA, and they're very concerned. We're all very concerned about the overgrowth and the traffic, and it's terrible up there. And of course, it seems like growth comes before there's a solved problem of the traffic. And so we, of course, there's been some traffic improvements there, but this Quick Trip is going to be a nightmare. Of course, it's already approved. That's not the question, but we ask that you take that recommendation and deny that. Thank you for your time.
Thank you.
Next, Mr. Chairman, Thomas Johnson.
My name is Tom Johnson. I live at 42 Cloverleaf Court in Noonan. I'm here also on the Quick Trip variance request. At the last zoning hearing, the zoning variance request hearing, it became clear that a secondary effect of the variance request is that there was going to be additional truck traffic, additional truck parking as a result. The Quick Trip people have indicated that traffic will go on to LZ Johnson Road before it goes back onto 154. At the last hearing, it was mentioned that a light was going to be put in there. Documents were sent to us this past week indicating that that light is not happening for another year or two. Therefore, the increase in the truck traffic is going to have a negative effect on both residents and businesses in that area. And we oppose that at least until that light has been put in.
Thank you.
Next, Mr. Chairman, Maisha Rashad.
Good evening, Maisha Rashad. My address is 260 Peachtree Street, Atlanta, Georgia. Here on behalf of Sydney Foods LLC, I realize I just have 3 minutes, so just piggybacking on what was just said right before me about the Quick Trip located position item 12 on the agenda. Our client's opposed to the application because the layout will conceivably cause a existing ingress and egress on a shared easement. That would make that problem worse. So our position is also that, as the staff concluded, that they have not met the legal standard of proof of hardship required for a variance. And so we're just also asking that you take the recommendation and also deny the variances.
Thank you.
Next, Mr. Chairman, Andrew Hitch.
My name is Andrew Hitch. Address is 35 Oakside Drive, Noonan, Georgia. I'm here on behalf of Coulter Homes. I'm the community director with them. Piggyback off of what Dustin, we're trying to get clarification based off the ordinance. It's really just the one line item where it says no more than 3 permits shall be issued for every 100 lots proposed for the development. We're trying to get clarification on proposed development. Is it the entire development as a whole, like what was approved at the preliminary plat? Or is it by phase? Because our definition and most people's definition of development is the entirety, not just a phase. And I think there's some confusion with that. So we'd like your help trying to clear that up. Thank you.
Thank you.
Last speaker, Mr. Chairman, Michael Burke is the applicant for item number 12.
Good evening, Commissioners. Michael Burke, 952 Old Peachtree Road, Lawrenceville, Georgia. Here representing Quick Trip. I'm the applicant for item number 12, and we can go into this a little further as the case is heard further down the agenda. However, we're here requesting a variance for a building setback as well as parking needs for that development. And I think some of the opposition you're going to hear this evening is more focused on the use and not necessarily what we're speaking about here today, which is the need for a building setback variance. And that's really due to the topography of the site, which is one of the bars or one of the boxes that needs to be checked in the application of a variance application. And we're also requesting a parking variance to allow for 73 parking stalls at a convenience store where we're currently only allowed, I think, something like 21. We've got an existing store on Bullsboro Road right up the street here that has 35 parking stalls, and we were granted a variance for that location just a couple of years ago to increase the allowed parking there with an additional 14 parking spaces. And we've actually experienced a good problem at that store where businesses blossom there at that location. And we have the advantage at that location of having some parking stalls that are off-site that customers are using. But on a couple of occasions, I visited that store and the property is overrun with customers. And really this kind of devolves around the county's requirement that any additional parking stalls would have to be on pervious pavement. And that really flies in contrast to what the Georgia Stormwater Management Manual would require for convenience stores, which are defined as a hot spot or a potential hot spot where there is a potential for fuel impacts to get into the soils and groundwater supply. And really, we're just here, Quick Trip, trying to do the right thing and not impact or at least introduce the potential for impacts into the groundwater supply by asking the county to approve a variance for some more parking stalls so we don't have to put in pervious pavement. But we also realize that at that location, we're allowed to have up to 75% impervious. And our current plan is showing somewhere in the range of 40% impervious on that site. So given that, we'd still be allowed to put the amount of concrete that would be required for parking. Just per the ordinance, we would not be able to stripe it. And then going back to the building setback, that's really driven by the 135-foot requirement for all state routes. And in this case, it's a little arbitrary that the 135-foot requirement is being posed to every state route in the county. At this location, traffic isn't as bad as Bullsboro Road, yet there's going to be an allowance for a right-of-way that wide. And GDOT currently has a plan to convert that roadway into a 5-lane road section.
Thank you.
Thank you. That's all, Mr. Chairman, for items on the agenda.
I'm sorry that you're not out of order right now. So. No, you cannot. No, thank you. So we'll move on to the agenda, starting with item number 5, request for additional 12-month extension on the opening of the new distilled spirits and wine package store filed by Dan Zavada and operation of Arbor Beverage Center, LLC, located on 154 Noonan, District 3. Is that District 3?
On June the 28th, the Business and Alcohol License Division received a request for an additional 12-month extension with supporting documentation. The applicant, Daniel Zavada, Arbor Springs Beverage, had begun the plan development for the facility that was approved by the Board of Commissioners on February the 22nd, 2022. Subsequent to that, Coweta Logistics began a development of Regional Impact Review, DRI, number 3688, on May 27th, 2022. On June 30th, 2022, Quick Trip 1746 began a development of Regional Impact DRI 3753. When the methodology meetings were held, the engineer for Arbor Beverage Center was contacted and asked to participate with the 2 DRIs because the properties were all involved with SR 154 and Elijah Johnson Road. Arbor Beverage Center agreed, but with that came time delays caused by traffic analysis agreements with engineers, GDOT, and local transportation reviewers. After getting appropriate data collected, DRI number 3688 and number 3753 have progressed. Arbor Beverage Center has been able to proceed with the land disturbance permit, but now has construction of the facility. With the delays that have been seen with the 2 other package stores related to materials, equipment, inventory, consideration of an extension would seem appropriate. The participant by the applicant in the 2 DRIs has caused the delay, but will yield a better transportation product for the county and its citizens. And staff recommends the board of Commissioners consider the request as presented and the extension they're proposing go to August the 22nd of 2024. And Mr. Zapata, see if you have any questions.
So we were wondering as we drive by how he was going to do that in 12 months. Anyway, I just have a few questions. First of all, is 12 months realistic, or do you need to extend that so he doesn't have to come back in the event he runs into any kind of a hiccup? Because it took these other stores 12 months plus, even when, and they were already had their land cleared and like that. So that's the question I have for you guys. Is it? And I don't know about what my colleagues think, but
I don't think it would hurt, but I don't know how quickly they could get the building up. We've seen issues with material and getting the inventory in because it takes so long for the distributors to get the inventory in and the amount that we require them to have. So I would.
what do my colleagues think?
Do we need to extend it to 18 months?
Yeah, I'm just trying to say is I don't want, because like I said, that was a big thing with the one on Posey was it wasn't so much the building, it was the inventory fill.
The inventory.
And it was taking months.
Once we release the license to the state, there's a process to it. The state, it takes a couple of weeks for them to get it back to them. Once they get it to them, they have to get it to the distribution companies and set up the accounts. And then it takes about 6 weeks from the time they get the state license until the inventory starts coming in.
So what I'm thinking is if we give him 12 months to get the store up, then he's going to come back and say, look, I got inventory issues now. I can't. So
I go with a longer day.
I would recommend that we change that condition to 18 months.
18 months, I think that would be reasonable.
Are you okay with that? Any further discussion? All in favor?
Aye.
Thank you.
Thank you. So 18 months.
18 months. Next one, item 6, request direction from the board regarding condition 13 associated with the previous petition REZ 22-21 filed by Turnstone Group LLC for the property located at 3967 Lower Fayette Road, Noonan, District 1.
Mr. Chairman, Attorney Griffiths has already spoken to this, but this comes back to the requirement on the 12 months. As noted, her comments were correct. We do have a construction plan set in. Comments have been made by our staff, have been sent back. We were waiting on, I believe, 8 items to be addressed. And coming back in, once that's done, the LDP and then construction will be again on the site. We believe, based on previous situations, that with a 4-month consideration of setting the public hearing as we did at the last meeting would be appropriate, and we feel like that at that point you will certainly have a structure coming up at that site. I'll be glad to answer any questions you have in addition to that.
Angela?
Yes, sir.
There was a issue with the water there, having to transfer some rights or something. Did that get worked out?
Everything, to my knowledge, it's matter right now. It's just a matter of getting all the plans and all addressed.
Okay.
And getting those comments back. But to my knowledge, everything is ready to go.
Okay.
So, and they've been working with your department
Yes, so
through
they
this
have
whole
been.
process.
Okay.
of
And
I know it's
evidence.
like
They
you said.
were, and as Attorney Griffith said, there was issues regarding previous ownership. Sometimes multiple family members can take a long time to get
I know all
everybody.
about that.
So we won't get into that kind of thing, but yeah, I think we can got to put a picture together. Once they started coming in with us, they have been active getting responses and documents in-house, and we feel like with a 4-month extension to set that public hearing, the applicant will have met your requirements, and just as the last when you granted the extension, they've already met the requirements and they're doing theirs, and we believe they'll do the same thing.
I make a motion be approved.
Can I get a date that you can give me a date, Michael?
Are you asking for 4 months?
4 months.
December
The date
7th?
would have been August 9th, would have been their
December
deadline.
7th, would that be a short one, or do you want to take it into January? Because December 7th wouldn't quite be 4 months, would it?
December
right
9th
at
would be 4 months.
December 7th.
Okay, all right.
I
Then
make my motion December 9th.
December
it's
7th.
the 7th.
7th, whatever.
Okay, so that's the condition,
Oh, for the
December 7th.
public hearing, I'm sorry.
Yep.
And
And that was a big family. I know
Bob
that
second.
has been interesting.
Okay, so
How many kids? Was it
Commissioner
9?
Poole, Commissioner Poole motioned in, Commissioner Blackburn seconded with asked conditions. Any other discussion? All in favor? Aye. It carries unanimous. Item number 7, recommend approval of petition VAR 2314 filed by Peachtree Senior Partners, LLC, Celebration Village, requesting a number of floors variance for property located at 478 Fisher Road, Sharpsburg, 4th District.
Mr. Chairman, these next 8 cases on the docket, Ms. Eschman and I brought to the Board of Zoning Appeal at their July meeting. As you called, variance 2314, the request from Celebration Village was to allow a 4-story structure. This would allow a smaller footprint, adding more green space, and just adding another floor on this. That's a requirement under our 23. So with that, we bring the recommendation from the Board of Zoning Appeal with well, excuse me, there was one person that spoke in opposition, but it wasn't the structure, it was just the community itself, asking for the structure being limited to the 4-story, 55-foot, and the building permits meeting all applicable codes. That comes to you from the Board of Zoning Appeals, and again, just to kind of give you a show of their proposal, and again, the site.
So there is no variance to height than what they previously were
They had
approved.
already received an administrative height variance.
But they're not asking any
So this is
deviation
simply
on it.
the 4 stories because they are permitted for 3.
And the unit count reduced?
I believe there's a reduction in count just going up and making a smaller footprint on the site.
So you're saying that originally there were 3 stories?
3 stories, yes, sir, and
And-
that wouldn't require anything from the board. And then they came in and added for some height, just for design. And once they started evaluating it, actually, a lot of times, once you start putting ink on the paper, they found that they could go to 4 stories, create a better combination. They're taking some other structures, putting all together in this one building. And
So the
having-
building does not exceed the height restriction?
It doesn't now. It's already received an administrative height variance,
So
so
they're
that's
just
done
going to
in-house.
compact the floors so you can get 4
We
floors?
would need to go up to the 4th floor, yes, sir.
I have a question. Are the materials in that 4th and 3rd floor still non-combustible?
Everything will still meet the requirements that you put on the original approval, sir. Just continue up.
Thank you.
Certainly.
If there's no other discussion, I'll make a motion to approve.
Second.
With the 2 conditions?
With the 2 conditions, yes. Any other discussion? All in favor? Aye. Carries unanimous. Number 8, recommend approval of petition VAR 2315 filed by Stephanie Davis requesting an easement variance for property located off Smoke Road, Noonan, in the 2nd District. Is it Smoky?
Smoky Road.
It just says smoke on mine.
You should know better.
I learn something new every day.
Yeah, right.
Go ahead, Ms. White.
That's okay. Happens. We're loading a little slow here. Mr. Chairman, as previously, this case was also heard by the Board of Zoning Appeal at its July public hearing. Ms. Stephanie Davis filed this article under 24, Section 24623, Item 3. This is a situation where the applicant is requesting a 4th residence on an easement. Again, this property is located behind 2017 Smoky Road. The recommendation comes to you from the Board of Zoning Appeals recommending approval with 2 conditions. One being that no further land division be done off of the tracks 1, 2, 3, 4. And then number 2, asking for a written notarized easement rights on all those involved. Let me take you to the site plan. This is a kind of a unique situation. Thank you, Lisa. Got Smoky Road coming in here. We've got, it's one of these unique situations where we've got some separation where over time parcel property was at one time owned several years ago in one family, and then property started being divided out and sold. We certainly have different processes for recording documents and all now. The applicant has got this parcel that they would like to be able to have construction. We have no access point here. We've got an easement serving these 3. Now wanting to get to this lot. The staff comments that went to the Board of Zoning Appeal based upon our transportation from our Public Works Director was to come in and put a cul-de-sac at this site, having one drive coming off of that serving number 1, And then that from the cul-de-sac, then you would then serve 2, 3, and 4, and that would then keep you from having to deal with that, as well as establishing this drive off of here with a proper drive, as opposed to basically just turning into a driveway going through this property. So that was the original recommendation that came. Our Public Works Director provided a drawing so you can see what their intent was. Maybe it's a little better for you can see it. Again, right now it just comes in and comes out to the property. This would allow a cul-de-sac. Then you could serve the property as well as the other 3 from that, not creating the 4th easement. So we bring you that this evening so you can see what our original recommendation went to the board with their comments, and then having the information before you this evening. Be glad to answer any questions. I don't know whether you
Ms.
want
White.
to see. Yes, sir.
Give me just, I guess, do we have any history on this road that does not have a cul-de-sac at the end of it? That just seems to me that we really need to put a cul-de-sac at the end of the road, if nothing more than for a turnaround for a fire truck.
Well, for any kind of emergency vehicle, or for that matter of fact, a school bus, something
Right.
like that could get down there and turn around. Now they're going to be basically turning around in someone's yard.
It is the applicant willing to consider this and possibly donate the right-of-way or property that we could take care of this, or half of the cost, or?
I would say based upon the public hearing at the Board of Zoning Appeals meeting, they were preferred to just use the existing drive and come down to the 4th drive, creating the 4th easement or 4th access off the easement, as far as as opposed to creating the cul-de-sac.
Have we ever done this in the past, where you've varied an easement requirement to allow someone to have a 4th access point?
Haven't we?
I would say that we've done, I think, 2, where it's been very unique situations of land. We made changes to the ordinances several years ago. We had some different reviews as far as how we did easements. So we made some changes to make sure that we did the 3 to the easement. We've been doing 3 to easements and doing, like, if you did a double, you could do the 6. But we made changes in that, so we didn't get into issues with that. Since that time, I believe we've had 2 that have come in, and those were unique situations where we got into basically some landlocking. We've not run into a situation where we have a road that just ends into property.
Well, I think my understanding, though, is that this is what, I guess, Mr. Hanley thinks is best, is to just, if there's are we paying for the cul-de-sac? Or, I mean, if they donate the land, I mean, would you guys complete the cul-de-sac, or?
Well, I guess ultimately that decision would be up to the board. As several of you have stated, the dead-end road without a cul-de-sac is an issue for not only emergency vehicles and school buses, but you think about garbage trucks. You think about Amazon drivers that come down the end of the road and don't have anywhere to turn around. We get those calls all the time, especially from school bus drivers that don't have anywhere to turn around. And then the hard and fast rule that we've had over the years is that we don't allow more than 3 lots to access a single easement. And if we were to open that door,
right,
then there are hundreds of easements
I know
around
some
the county
personally.
that we could begin receiving requests for to provide another lot or 2 more lots. And I don't think we want to put ourselves in that position. So that's why we looked for an alternate resolution here than just to approve a 4th lot to this easement. If we could get the right-of-way for a cul-de-sac, then Lot 1 would have right-of-way frontage and wouldn't need an easement access. And then the easement could still serve Lots 2, 3, and 4. and would comply with the current regulations. And then at the same time, we're solving the issue with the lack of the cul-de-sac on that roadway now.
So are you saying that with the cul-de-sac, the ordinance is still intact?
Right.
Correct.
But if the cul-de-sac is not present, we'll be making an exception,
Correct.
which we are not wanting to make?
That's right.
There's a lot of them. I mean, I've gotten personal calls, Mr. Smith, about that same issue, and I've told them that the ordinances won't allow it.
So is the owner proffering the cul-de-sac?
No, so the owner's not proffering it. That was one of the conditions that, from our staff report, we had presented to the Board of Zoning Appeal that I have up there for you now.
What would, I mean, I'm not going to hold you to an exact number, but what would your projection be on making that a cul-de-sac if they donated the land?
If the applicant were to donate, I
right
think
of way.
there's 2 parcels that we would need right away from, based on the plat that we've reviewed for Mr. Harbuck. I think that the applicant would need to donate about 0.12 or 0.13 acres, and then one of the existing property owners there at the end would need to donate 0.07 acres, I think that I calculated. And that's a rough estimate just based on my sketch. The cost of a cul-de-sac, if the county were to build it, we could probably build a cul-de-sac for, including the grading and all the materials, probably less than $20,000.
Okay. Because you did that one out off of 154. What was it, Glen?
Yeah, Glen Forest Drive.
Yeah, Glen Forest
So
Drive.
in that case, the applicants constructed that one.
Yeah, they did
They
that.
had 7 lots they were serving, so they split the cost over those.
But they don't, but then we took.
Donated right away.
Okay,
Yes.
okay.
So just to be clear, what I see is that Bozel said this would be all right without the cul-de-sac. Is that correct?
That's their recommendation.
All right, and then what I'm hearing Mr. Hanley say is that we really need the cul-de-sac.
The cul-de-sac would be advantageous not only from the perspective of allowing the lots to be served from one easement, but it would also help serve the neighborhood itself and the community itself by providing an area for school buses, garbage trucks, emergency vehicles to be able to turn
So
around.
it's a
at the
safety
end of the
issue.
street.
Yeah.
Yes, sir.
My recommendation would be that that the cul-de-sac would be required in order for this petition to be granted.
And I would have to agree with you, Mr. Smith. So,
Bill?
Bill, what do you think? What are your thoughts on that?
I agree with Commissioner Smith. I see it more of a safety issue. This road's been there for a good number of years, and probably over that time, we probably should have either added a cul-de-sac or had the people who live on that road add one or donate the property. But I don't see us going and approving the divide by 4. We need to stay with the ordinance, which has the 3 off of one easement. So,
So would this be a motion to deny, or would, I mean?
What y'all wanna do?
Well, no, if we wanted to put a cul-de-sac in, would we approve it based on that
You would
condition?
based on the condition,
Okay.
and they couldn't do it unless they complied with the condition.
Okay, all right.
And I might would add that unless Mr. Lee thinks otherwise, just direct staff to work with the property owners to get the necessary right-of-way.
I mean, they don't have to donate it, but if they want the cul-de-sac and that's your condition, then y'all don't have to give them the variance either.
Yeah, right,
unless, yeah,
right.
so with those conditions, we can approve this?
My suggestion would be,
It
if
would
you
be
do not
make-
want it, I would say motion to deny, and then separately direct staff to acquire the right-of-way and construct around the cul-de-sac.
I think I would word that differently, because I mean, I don't think that, we're helping them out by, putting the cul-de-sac in, and I don't think we need to acquire any of the land. If they want to give it to us, we'll put the.
Oh, yes, I meant donation.
Okay.
So what I'm hearing now is that we could approve this with the conditions that a cul-de-sac be made part of the
If you
approval.
approve it, it's going to be granting the 4th access to
Yeah, that's why I said we have to deny this one
If
first.
if that's what you want to do, then yeah,
Yeah.
that's how.
My
If
motion
you would
would
just
be to
deny it, and you
deny
would
it.
instruct staff.
Second.
that's not part of it.
So I'll second that motion. Any further, any further discussion?
It is out of my league here, but would a Hammerhead have an application here? Less money?
Potentially, it would impact probably impact one of the existing residences there more than the cul-de-sac that we proposed. What we tried to do was sketch the cul-de-sac where the majority of the impact is to the property that has not been built on yet.
Well, I'll guess what kind of money for a Hammerhead, if,
Probably a little less, maybe 10,000.
I still like the idea of
Okay.
turn around for
the,
the,
right,
as long as we don't open that Pandora's box on that fourth one.
yeah.
Okay, so then the
Motion
motion,
to
there's a
deny.
motion
Yes.
and a second. Any other discussion to deny? All in favor? Aye. So this is denied, and then I'm going to ask staff to work with the existing property owners to come up with a plan if they want to put a cul-de-sac in and come back to the board. Oh, okay, yeah, I'll make a motion for the staff to do that.
Second.
Any discussion? All in favor? Aye. It carries. Unanimous. Okay, item number 9, recommend approval of petition VAR 2316 filed by Crestwind at Spring Heaven requesting a model home variance for property located between Union Crossing Bypass and US Highway 29, District 2.
Mr. Chairman, the document before you this evening is to be able to go in at the location there at the Crestwind development on the Noonan bypass, to go in, and the recommendation coming in from the Board of Zoning Appeal is to provide for the model home community with a maximum of 15 lots located within the designated section of the development, no other sales lots being available within the development. Again, community being designed as presented to staff and meeting all bill, fire, emergency, and utility codes as provides to the mobile home ordinance. Let me take you to the site so you're familiar. The location that we're speaking of is in this area here. And then let me take you to the site so you can see what they're speaking. Basically, this would then be the community. They would have the parking here, a design center here, a welcome center here, and then you would have these other lots involved with homes where they could go in and see the different styles of homes. If you remember back during the rezoning, there were different sizes and dimensions and whatnot involved with the homes, so I'm certain they would have those laid out. And then, as was spoken about, they could then go see those in making their choice. So this comes to you in recommendation of approval from the Board of Zoning Appeals, again noting this and the conditions, the 3 conditions associated with that.
On these, the model homes, what bothered me from the time that they wanted to build these model homes was that we were supposedly looking at the ordinance, and the ordinance was saying that you can build 3 model homes for every 100 permitted. But then, as we looked at the ordinance, it says proposed. Quite honestly, if they've got 8 or more designs, I think it's a little ludicrous in us to believe that they're just going to build 3 so that people can only see 3 of them, but they won't show the others. And I have to say, I'm in support of them being able to build this model home community with the 15 lots that they are requesting. And then if there is wordage in our ordinance that needs to be corrected, then we need to do that, or take a look at it at least. But Counselor, I've always heard that the law is the law. And that's the way I saw this particular situation, instead of the 3 that they basically could build 15 or more, really.
Well, in this situation, you're lucky because you were the legislature, and y'all can make a change. I understand that, but my understanding is this request is just specific to this. We can certainly look at the ordinance, but the request before the board is just for this development, is my understanding.
That's correct.
Yes, sir.
So my question is, and maybe the the developer can speak to this. How many how many price points of homes are we talking about? And please give your name and address.
My name is Larry Long, Vice President of Coulter Homes, 130 Hartwell Court, Houston, Georgia, 30458. You asked me how many price points?
Correct.
We've got 4 different series of homes, Mr. Smith, and it's a 40-foot series all the way to a 70-foot, which ranges from 1,500 square foot to about 3,000 square foot. So we'll have at least 4 series of price points, and then those series will range from $400,000 to $800,000.
Okay, and that's what I thought. And so from my viewpoint, you have different floor plans for each different price point. So there's 4 different home styles, square footage.
Yes, sir.
And then you have multiple floor plans for a square footage home of each of the 4 price points.
Yes, sir. And let me clarify, and I may have confused you, but we'll have a floor plan for every product we provide, not every elevation. For every home that we will build in the community, the buyer will be able to go see that home and what it looks like inside. But, on the outside, we have different elevations. We can have 4 different elevations for one type house, if that makes sense.
I hear you. And our concern is that development would proceed as planned without any hitches, pinch points, or hiccups. And if we are granting the 15 homes to be built, and heaven forbid something would come up, I would just recommend that you build 4 of the homes, model homes, and be able to show people what the different floor plans are. So instead of 15, I'm recommending 4, and you can use the floor plans that I'm sure you have beautiful drawings, and a virtual tour would prevent this from getting out of hand.
I appreciate that. I think the confusion here is when we first started this process, we approached the county about doing a model home ordinance that you didn't have at the time, based on what other jurisdictions in the state were doing. So we went to the county staff. They required us to go to the fire marshal to actually put together a process by which the county could consider doing a model home ordinance. And the language we came up with that we helped them draft, or we recommended them look at ordinances to draft, was 3 per 100 of the total project that we were going to do. The total project that you guys approved in zoning was over 700 lots, 738, I think it was. After that process, we were required to give you guys a preliminary plat that showed the entire project of 738 lots. It was exactly the way it's supposed to be laid out. It took us 4 months to get that approved. Then the next step is you go in and get an LDP for your first phase, right? And when we submitted the LDP, we had our model home part based on 3 per 100 to do the model home part. The reason, Mr. Smith, we do that is because we want our buyer to see all the products we're going to provide, which is about 15 different models. That's the models we have, all in the constricted area that we market to. And we've met every condition that of the ordinance y'all adopted, the model home ordinance, from fire protection to road, everything. We spent about $1.2 million already building the model home park for the model homes. So we would like to go ahead and build the 15 that we typically do in every community that we do. We did in Peachtree, that y'all seen. That's the way we know we can allow people to see everything that we build, so there'll be no question about what. And I understand what you're saying, but that's why we're asking for the 15.
Okay, I appreciate you explaining that.
And if I can comment a little bit too, because as this was presented to the board, this model home ordinance, because we'd never seen it before, and the language was written where it says proposed. Now, what I assumed, but they were not permitted plats, it was a proposed development, and that's how I read it, and that's how I voted on that ordinance at that time. So I could see how somebody could misread that, and because when I looked at the two drawings, I looked at the preliminary plat, which all department heads had signed off on, and there was 750 homes in that presentation. And then the final one that came in to get the model homes, it was a different story. So I'm having to agree with my colleague, Commissioner McKenzie, on this one, because that's the way I read it. That's the way I voted on the ordinance, and that's the way I interpreted it. So that's just my 2 cents.
So we've got a recommendation and a second, so now we vote on it, right?
Well, I think he wanted 4, Bill's okay with the whole park.
Well, I'm okay with the 15 lots that has been proposed, not only by myself, but for BOSA, it came through them. I think, personally, I think that they need to have more than 3, actually more than 4, to be able to show the product. We've allowed them to come in, whether you agree with that or disagree or whatever, but the project's coming. So I'm just an old country boy, and all I know is that I think that you could sell a whole lot more vegetables if you had more than 3, 3 different kinds. So my motion would be to follow the recommendation of the BOSA board with the 3 conditions that they've laid out.
And I'm seconding that.
Okay.
Any further discussion? All in favor?
Aye.
Opposed.
4-1. Carries. We're going to take a short recess here for 10 minutes.
Oh, I want.
I can't stand it. So he said he went from 300 miles an hour to 500 miles an hour. I asked the pilot.
So we'll continue the public hearing.
They cut out a 40 minutes.
VAR 2317 filed by Marshall Bedford requesting a rear yard setback variance for property located at 150 Maple Leaf Road, Sharpsburg. District 1.
As you call, Commissioner, VAR 2317 is requesting a rear yard setback. You've heard quite a few of these in the Timberbrook. This is part of the RRCC product, where we're seeing these smaller yards causing issues when we're not able to cover the patio. So the request for you this evening on behalf of Mr. and Mrs. Bedford is that consideration. There was no opposition. We actually received several letters of support from surrounding neighbors. Board of Zoning Appeal brings this to you with recommendation of approval with the 3 conditions, noting the 10-foot reduction, the approval from the HOA, and then all building permits being obtained.
I make motion to be approved with the 3 conditions.
Can I ask one question, though? Sure. See, since it seems like we see these every meeting, is there a way that we can make an administrative, let them have an administrative right not to exceed a certain, because they're all coming for 10-foot reductions?
Michael and I have already talked about that.
Oh, I didn't know if you could do that. I'm just curious.
We could look at the ordinance
Okay.
and see if we could expand. I think Commissioner McKenzie's asked for the same thing, to give our director, his designee, the administrative ability. We can look at that.
Okay, I appreciate that. So I'll second your motion. Oh, Mr. Smith seconds it. Any other further discussion? All in favor? Aye. It's unanimous. Item 11, recommend approval of petition VAR 2318 filed by Catherine Malone requesting a rear yard setback variance for property located between 1778 and 1880 Mount Carmel Road, Noonan, 2nd District.
Ms. Malone is trying to build a home here on this 5.82 acre site. With it, probably give you a little visual, help you understand that this property really leaves itself such that a variance is required basically to be able to do any type of structure. We've got floodplain, we've got a pond, we've got buffer requirements, which is leaving a very small location here to place a home. The application came through public hearing, no opposition, requesting the rear yard reduction, allowing for the 10-foot rear setback. Again, no opposition from the adjoining property owners. This comes to your recommendation of approval from the Board of Zoning Appeals with the two conditions of the requested 40-foot and then all building permits being obtained prior to construction.
I'll make a motion to approve with the two conditions. Right.
Any discussion? All in favor? Aye. It carries unanimous. Item 12, recommend denial of petition VAR 22-37 and petition VAR 22-38 filed by Quick Trip Corporation requesting front yard setback and parking variance for the property located at State Road 154 between Eliza Johnson Road and I-85 in the 4th District.
Mr. Chairman, I'm going to present this to you as one. There are two individual requests, and I'll cover both of those. The first being in the Article 23 front setback. The requirement is 135. They're asking for 95. And then the second request is, as was mentioned earlier, requesting the parking that had been denoted by our development review team. They would be allowed 37. They're asking for 73. Public hearing was held on the site. Let's talk a little bit about some of the arguments as far as location, being able to move it forward in regards to other facilities that are on site. Those were there prior to any current dimensional requirements. So that's why those are located there. If there's any issue of are there any kind of favoritisms, and there's certainly not. Those were just there under a different time and different setbacks. Now, obviously, as you know, the road widening work is looking to come through, and hopefully we'll see something in the next few years, seeing that road widen. So that addresses on that first. And then, again, the parking expansion, they speak to the fact of being able to use pervious markers. As our development team noted, they can use the pervious paving. They can certainly incorporate the area there. So the development team could not see any support coming to this from the board, to the Board of Zoning Appeals. Public hearing was held. Both of these came to you this evening for denial. Be glad to answer any questions. Certainly have Mr. Sewell here from the development team, can answer any questions you might have with that regards.
Can I ask you a question about the parking?
Yes, sir.
So the additional parking is planned to be in the rear of this development, in the rear of the store?
No, sir. I think they're going to incorporate parking all over the property. As you can tell, we've got parking located on both sides here. We've got parking here. We've got canopy out front here, and then we've got the tractor trailer parking in the back at this site coming out on LZ Johnson Road here, then connecting here with State Route 154. So no, sir, it will be all over the property.
So you really can't identify where the extra spaces are going to be?
Well, I mean, obviously, if you incorporate these, I mean, one of the comments have been made if they want to be able to keep the store, because there's some issues. Obviously, we are not blind to the fact that we've got some stream issues back here. We also acknowledge there's some topography issues there that are going to require some additional fill and pack for that to be done. But as has been noted, you can certainly move the canopy to the side and get everything in there and keep the store where you had the store. So those are options there. And no, sir, you cannot specifically identify those simply by the way they've laid them out.
All right. So in other words, they have to produce a new schematic to show.
Well, when they submit it to staff, they will submit it based upon what you approve.
All right.
So I have a few questions. So what was their documented hardship?
As presented to the Board of Zoning Appeals, they noted that having the canopy out front was a marketing recognition as you're coming off of State Route 154 there off I-85. You'll certainly see that canopy because we don't allow pylons. So when that canopy's up in the air, they are allowed to put signage on the marker there. So that would provide them some visual there. That's not a hardship. That's just a change in marketing abilities. As far as, we certainly understand We certainly acknowledge the setbacks here, no argument there. We acknowledge the topography. Our development team does not see the issues associated, no matter what kind of, whether you put pavement, whether you put pervious spaces, or whether you put pervious pavement down, you're going to have to maintain the property. So regardless of what goes down, there's going to be maintenance issues. There's maintenance issues at my house. There are at yours. So there's going to have to be there's going to have to be work done on the site. So that was, that's basically been what has presented to us.
So what are based on the site footprint and the layout and everything, what is the required parking spots?
I can't remember, Angela, in this case. What was the parking total?
37 was the number presented by development.
We have a maximum impervious parking allowance, and they're requesting to go over that. We count the spaces at the fuel pumps, which we're not saying those have to be pervious, but the additional spaces above and beyond that is what we require to be pervious.
And then I think the applicant made a correlation between this and the one off of exit 47. So when I look at this footprint of the store and the pump makeout, is it similar? Is it identical in size? I mean,
I don't recall off the top of my head, other than to think this one is quite a bit bigger with the truck facilities.
Okay, that's right. You got a truck stop there. That's right. So
There's, to give you a perspective, there is parking on this side. If we were at State Route 34, that store faces this direction. They have parking over on this side, but they don't have the double rows like you see here.
Okay. So, and then also, the one thing that concerns me too is obviously the comment you made early on about, that eventually will get widened.
Yes, sir.
And and when you look across the street, and you see the gas station and you see the Waffle House, and if you give them that setback variance, GDOT's not going to change how they're going to do that widening of the road. So there may be an acquisition of commercial space now, which is going to be a whole lot more expensive when you look at right-of-way acquisition. So I'm not a big fan of allowing the setback for that very reason as a taxpayer. So and I think community development, if you're giving them the 37 spots, that's what you calculated, and that's what are you calling for, I would tend to agree with your decisions on that. So, any other comments? So, I'm going to agree with Boza and ask for a motion to deny. I'll make that motion to deny.
Second.
Any further discussion?
Is that for both variances, Mr. Chairman?
Both variances,
Okay.
yep. Any further discussion? All in favor? Aye. Carries. Item 13, recommend approval of petition VAR 23-19 filed by George and Christina Hammond, requesting a front yard setback variance for the property located at 120 Macedonia Woods Drive, District 2.
Good evening, Mr. Chairman, board members, staff, and citizens. As you mentioned, this is petition variance 23-19. It has been filed by George and Christina Hammond. They are requesting a front setback reduction for property located at 120 Macedonia Woods Drive. The applicant is proposing to construct an open carport area along an existing turnout here on the driveway. The open carport will be approximately 12 feet by 20 feet, and as I said, it would just be positioned right over, this is your existing driveway turnout here, and the carport's just going to fit over that existing turnout. They are requesting the front setback from 45 feet from the required 50, reduction of 5 feet. At the Board of Zoning Appeals held on July the 27th, there was no opposition, and the Board of Zoning Appeals recommended approval with these two conditions. The open carport area should not be located any closer than 45 feet from the front property line along Macedonia Woods Drive, and two, the applicant shall meet all the requirements of the building department.
Any discussion?
I'd make a motion to approve the recommendation by the Boza Board with those two conditions. I think it was two there, yeah.
Right. Okay, for a motion, a second. Any further discussion?
Can you go back? Oh, thank you. Thank you for going back. So the sketch on the left,
This is just, he presented this with the application, just showing his existing driveway as it is now, with just the existing driveway turnout there.
Okay, so then this next sketch where it is, that's the proposed canopy?
That's where he's showing you the proposed carports would like to be placed, yes.
All right. Thank you, Ms. Ashman.
Sure.
Okay, motion and second with conditions. Any further discussion? All in favor?
Aye.
It's unanimous. Item 14, recommend denial of petition VAR 2320 filed by Jose Gallegos requesting a front yard setback variance for the property located at 307 Palmetto Tyrone Road, 4th District.
Mr. Chairman, the applicant has constructed a 12-foot by 24-foot accessory structure without obtaining the appropriate building permits or inspections. Back in February of 2023, our Code Enforcement Division received complaints from several property owners in regard to the accessory structure. The Code Enforcement officer went out and has determined that the building was 90% constructed and issued a stop work order. After contact was made with the property owner, they visited the building department to obtain some information on gathering the building permits. At that time, it was determined that the accessory structure sits approximately 54 feet from Palmetto Tyrone Road, which does not meet the requirement of the 100 feet. In order, the applicant would like the building to stay at its location on the property, therefore requesting the front building setback to 54 from the required 100 feet, which would be a 46-foot reduction. We have had numerous complaints from February up until July the 27th. At the Board of Zoning Appeals, we did have 3 neighbors come out in opposition regarding the accessory structure. Therefore, the Board of Zoning Appeals did recommend denial of the request.
Can I get you to go back to that picture? And I don't know if the applicant's here, but I have some questions about what foundation are they using? I mean, did they have a building permit? I mean,
there were no building permits pulled.
All right, so this is the applicant? Okay. I need you to state your name and address.
My name is Jose Gallegos. It's 307 Palmetto Tyrone Road, Newnan, Georgia.
So what's the foundation it's on? It looks like it's on like stepstones or something like that.
This is in 24 for 24, and the concrete and the metal is 6 by 6, and the wood for guarding the floor.
Okay, I don't know if you can interpret for them. I don't understand. And I need your name and address too.
Okay, he said he has.
I need your name and address too, please.
Yes, sir. My name is Cassandra Gallegos, and my address is 307 Palmetto Tyrone Road. He said that the posts are set on concrete and they're 24 by 24 feet, and then in the middle he said there's a wood post that's 6 by 6.
Can you point the green pointer to that second picture in the left corner there? Yep. What is that?
¿Qué es eso que está apuntando?
Is that what the building's sitting on?
¿Está en concreto? Yeah. Yes,
Okay,
it's sitting on concrete.
That's not safe. So,
It has a post in the middle.
that's still, it's not safe though.
Dice que no es seguro.
It's not on a foundation. I'm not a builder, but maybe somebody from engineering, PE, John Ameson, can look at that and look at the foundation of that building.
Yeah, I don't think our building official would approve that.
Okay.
Okay.
Yes. Okay.
All right.
I mean, it looks like in a high wind, it would just go bloop.
So did you say the inspector did not go on the site?
Yes, sir, he didn't go inside the structure.
Okay.
Because there's no building permit.
Right,
full
right.
site, so he did not feel he could look inside, but basically he's looking just at what you're seeing,
Mhm.
concerns about the structure and needing plans, so he could see those, and having an engineer determine and confirm what's there, and then he said he still would probably ask for exploratory, so he could see it, because as it looks, it appears that part of that building is floating.
Yeah,
Nothing.
right, that's what I'm saying.
Is it a second home on that property? Or is that the
No.
primary?
You
The
said
applicant
it was,
advised at the meeting that the lower floor was going to be a storage building for his tools, and the upstairs was going to be his office.
No, he's saying, is there a house on the property now?
There is a residence there, yes.
So this would be a second home?
They identified
No,
a shed.
this is a shed.
is there going to be plumbing?
No, there's not. It's just a
just
shed for
electrical.
storage. The reason why it's in the front and not in the back is because the back is very muddy, and so my dad's truck has gotten stuck there several times. So he thought that was a good location, and our builder did misinform us, and he said that we didn't need a permit since it was a shed, when
Who
really
told-
we did.
Who told you that?
Our builder.
So you have a builder doing this?
Yes, there was a builder that did this. It wasn't us.
Well, I'm sorry this happened to you, but I don't know about my colleagues, it looks unsafe to me. And I would go back to my builder and I would bring him up and say, look, you need to come down and meet with community development, and this needs to be done properly. So you may have to, in fact, have to take it down and start all over again. But I'm going to recommend a denial of this based on Bose's recommendations.
I would second that motion.
Any further discussion? All in favor? Aye. It's unanimous. Thank you for your time. Item 15, request to set a public hearing on September 7th regarding petition REZ 2308 filed by Angler Investments LLC. Any discussion? Guess not. All in favor? Aye. Any appointments for boards and authorities?
Yes, sir, I do. I'd like to reappoint Lisa Mitchell to the Board of Zoning Appeal and thank her for her service and her continued service.
I will second that. Any discussion? All in favor? Aye. It carries
And
unanimous.
thank you, Shannon, for making the print and digging that for us. You're welcome.
Okay, bids and contracts. Item 17, request approval execution of the Third Amendment to the agreement with Georgia Transportation Infrastructure Bank associated with the Madras Connector Phase 1.
Mr. Chairman and Commissioners, at the commission meeting held August 22nd of 2017, the board voted to execute an agreement with the State Road and Toll Authority, or SRTA, for $1.5 million for funding from the Georgia Transportation Infrastructure Bank to be used toward the construction of Phase 1 of the Madras Connector. Delays in approval of the bridge designed by GDOT and CSX Railroad have resulted in a shift in the construction schedule for this project. The project is currently scheduled to move for letting for construction in January of 2024. Due to the shift, CERTA has agreed to an extension of the grant. Therefore, staff has recommended the board execute the Third Amendment associated with this grant.
I'll make that motion to approve.
Second.
Any further discussion? All in favor?
Aye.
It's unanimous. Item 18, request approval execution of an amendment to an agreement with Empower. You want to give us a brief summary on that, Michael?
Yes, Mr. Chairman. On May 3rd of 2022, the board voted to execute an agreement with Empower to provide third-party administration, or TPA, and custodial services for the salary deferral plan and employee matching plan, which would be effective December 16th of 2022. The transition is complete, but staff did note a minor error in the master service agreement. The third-party administration fees charged by Empower should be paid directly by the county. Instead, during the short tenure, they have been applied to the participant fees. So the agreement states that they would be taken by the participant accounts, so we're asking to revise that. We have been working with Empower, and they're going to credit those fees back to the participants, and the county would pay those fees.
Okay.
So staff is recommending approval of that amendment.
I'll make a motion to approve. Any further discussion? All in favor?
Aye.
It carries unanimous. Item 19, request approval to renew a lease for space utilized by the Department of Veterans Services.
Mr. Chairman and Commissioners, the lease agreement with the State Properties Commission associated with space utilized by the Department of Veteran Services, now located at 87 Noonan Station Drive, expired on June 30th of this year. The terms of the original lease provide the tenant with an option to extend said term for 5 consecutive one-year periods. Staff has received a request from SBC to exercise the first one-year renewal option. Just as a reminder, we do provide that free of use for the Department of Veterans, and the renewal would be July 1 through June 30th of 2024.
Motion to approve.
Second. Any further discussion? All in favor? Aye. It's unanimous. Number 20, bids and awards for Phase 1A of the Tornado Tree Program.
Mr. Chairman, Commissioners, the county, as you guys are aware, established a tornado tree assistance program regarding the March 2021 tornado to help property owners with damage to trees that are still standing on their property. We had Phase 1 that this board approved earlier in this year that was very successful, and because we had additional funds remaining from GEMA, you guys did approve Phase 1A. Phase 1A did include both city and county property owners within the tornado track. Based on the applications, there were 281 applicants from property owners. Staff from EMA with assistance from some city employees as well as our code enforcement employees went out and verified these addresses. They split them into 10 zones, and they went through and verified, again, eligibility. Based on that, staff received bids for all zones from 3 contractors, totaling $1,151,300 to perform removal of just over 1,000 trees. And so staff has recommended approval per zone on a low bid basis. As you can see, there are 2 contractors, White Meadows Tree Service and Boss Tree Service. And again, there's 10 zones, and they're allocated based on low bid. Additionally, because we are expending all the GEMA funds, staff recommends the board obligate an additional $396,200 of American Rescue Plan Act funds, or ARPA funds, to accommodate this bid.
And make a motion be approved.
Second. Any further discussion? All in favor? Aye. It's unanimous.
Mr. Chairman, I do want to point out Mr. Burgess, our EMA coordinator's here. Obviously, you guys don't have any questions, but just want to say thanks to him and Michael Terrell and their team. They've been out in the field, and as we talked about the other day, they have plenty of poison oak to show, but they've done a great
Did he get any
job
on their arms or anything?
working with the community. I think we've talked about 90 days, just to give you a perspective on, we're hoping to have some of this completed in 90 days, but given the weather and other things, it may take a little longer. But
Okay, well, I appreciate that.
Thank you.
Additional action items. Item 21, request approval execution of the local maintenance improvement grant application for 2024 districts 1, 2, 3, 4, and 5.
Second.
Michael, could you just give us a brief so the audience understands what this is?
yes, sir, Mr. Chairman, the Georgia Department of Transportation, or GDOT, is accepting applications for the fiscal year 2024 Local Maintenance and Improvement Grant, or LMIG, as it's called, for use of local governments to maintain and improve roads and streets that are part of the public road system. There is amount that's eligible for the grant, and Coweta's eligibility for FY24 is $1,789,054.84. It does require a match of 30%, which would be $536,716.45. And so staff is recommending.
And we
that
do typically get that, and we do the match.
Yes, sir.
Yes, sir. Okay.
And this is funded through the motor fuel
Yes.
tax.
So I got a first and a second. Any further discussion? All in favor? Aye. It's unanimous. Item 22, request set a public hearing September 7th, 2024 regarding the proposed fiscal year 2024 budget. Second. Any discussion? All in favor? Aye. It carries unanimous. Item 23, request from the town of Moreland for assistance with installation of poles, District 2.
I'll make that motion.
Second.
Want to give us a brief one on that one, Mike, please?
Mr. Chairman, Commissioners, this is a request from the town of Moreland for assistance with the installation of 2 poles. They are asking to place digital speed limit signs on Highway 29. Of course, that is GDOT's jurisdiction. Mr. Hanley has received authorization for the county to assist the town. So that's
Got a first and a second. Any further discussion? All in favor? Aye. It's unanimous. Item 24, request approval to utilize various county roads during the One Love Century Bike Ride event. And you can talk about that, but I have some questions.
So, Mr. Chairman and Commissioners, this is the 18th year that the One Love Century Bike Ride has been hosting this event. It is a charity bike ride. It starts and ends at Creekside High School in South Fulton. As part of the process, they do have multiple rides, including a 62 and 101-mile routes. Obviously, depending on those routes, whether they come into the county or not, there are a number of roads that are requested to be utilized, all in District 2 on the west side of the county.
Thank you.
I'm okay with it, go.
Well, but I just have is there a representative here from Bike Atlanta or whatever? So
I don't see anyone, Mr.
Okay, so the
Chairman.
only thing I'm going to say is Mr. McKenzie, I have ridden out there during this time on Hutchison Ferry and Roscoe and South Fulton Industrial Parkway, and they always expect automobile drivers to respect their roadways. I'm asking publicly that I would hope they don't ride 3 and 4 and 5 abreast when I'm going the same direction they are, and I have opposing traffic coming to me this way. So please single file it and let us get by. Thanks. So I got a motion and a second.
Could we also ask the sheriff in this situation? I'm sure he's going to have somebody there or a
Commissioner McKenzie.
liaison person or something.
Usually the sheriff's office does review these applications just to make sure. Honestly, it's probably an enforcement situation depending on the number of patrol they have on shift that day. I believe they're estimating 1,700 riders for this. Obviously, a lot of those probably won't be participating in the 100-mile ride, but it's really just going to depend. But I agree with the chairman. Hopefully, Mr. Bagley will convey the message to the organizers.
I live in that district as also when Mr. Lassiter was on this board, and he would remind them every time. But it seems like sometimes that reminder would fall on deaf ears. But we need to be careful, not only the people who are going to be driving cars and trucks, but they need to be as careful as we're trying to be with them. And I don't have a opposition to it at all, but I'm just saying it really gets dangerous sometimes.
So true.
All right, so I have a first and a second. Any further discussion? All in favor?
Aye.
Aye. It's unanimous.
No, I was just kidding with you.
Oh, okay.
Well, I'll make that motion.
And then Bob seconded.
Woke him up.
Okay, supplemental and non-agenda items, if there are none, that were none added. So public comment, I'm asked for public comments on items that are not on the agenda. I'm assuming we have some speakers.
We do, Mr. Chairman. We have several signed up to speak. I'll start in the order in which they signed up. First is Jared Craig.
Hello, I'm Jared Craig. I live at 45 Line Creek Court, Sharpsburg, Georgia, 30277. And I'm here to remind us that, or remind the commission that we were here on the 25th and we explained your authority and your power to vote on the issue of paper ballots. And I went through the statutory authority as to the level of, consideration to determine if we're going to use Dominion machines or go back to paper ballots. And I distilled the concern as the issue of impracticability. And that standard has been shown by the current reports that have been unsealed by the court cases and the lack of trust in the system itself. We also explained at that last meeting about the financial benefit to the county for going back to paper ballots. And we were reminded that there was a $600,000 budget request for additional machines where we don't know where that money's going to come from. So we're asking here that we put that issue, or that you put that issue on the next agenda. At your next agenda meeting, bring the paper ballot issue up. Additionally to that, we're going to submit a lot of written requests, but we don't want that to be an act of volatility from us towards you whatsoever. You are not the enemy. We're not trying to attack you. That's not the goal of the issue. But to bring a sense of urgency, because we have until December 26th to get the paper ballots back in place, or we will not be able to have paper ballots for the 2024 election. By law, we have to have the paper ballots in place 78 days prior to the primary election, which is March 12th. And those absentee ballots are the triggering timeline for us to get this in place. If we come in December and y'all vote and approve that, y'all have to have time to procure the paper, the simple applied machines, and to train the staff, which can be done rather quickly. So we're asking that you take the time and jump on this early. Last time we were here, one of the other speakers says, we wanted to be the point of the spear on this issue. But that's not really the point. It's the calendar is coming, the election's coming, and we need to be an example as we go through the state. I represent a lot of other groups and a lot of other things at the national level, but all of these elections start at the local level. Me and people like me are going to all the county commissions. We don't want to have other people waiting on us. We want to work in concert with every other county that is taking this issue seriously. So thank you. We ask that it be put on the agenda, and I believe that's my time.
Thank you.
Thank you.
Oh, thanks.
Next, Mr. Chairman, Linda Mink.
Where's Lynn? Oh, there she is.
Linda Mink, 51 Avondale Circle, Noonan, Georgia, 30265. Gentlemen, I submitted some information for you, and just real quick, I'd like to extend a sincere thank you to Ms. Zarang, that she set me straight, and also Ms. Gay. I submitted a FOIA request on August the 27th, and the first time that they have probably ever heard this out of someone that filed a FOIA. They responded to me immediately, and this is an extensive FOIA. I'm asking for 28 years of voter information so that we can prepare this spreadsheet that you're looking at. This is the entire state of Georgia, but it's a cost-benefit analysis, and we're going to break this information down at year by year and then provide that back to you. But when they responded to my FOIA request, I couldn't believe how inexpensive it was to pull this together. 28 years, and they only wanted $1,553 and some change. And they gave us a delivery date of September the 15th. I was shocked, and I just wanted to just sincerely say thank you for doing that. And that's going to help us to meet the deadline that that Mr. Craig outlined, December 26th. We're going to make, there's a team of us, it'll be Mike Nixon, Debbie Brady, and myself who are going to go through and compile and load this information into a cost-benefit analysis to bring back to you. And we're hoping to have that done, say, by October 1st. So we'll be back here to present information, hopefully at your first board meeting in October. But thank you again so much for the opportunity for us to come and address you, and hopefully we can work together to make this happen. Thank you.
Thank you.
Next, Mr. Chairman, Mike Nixon.
My name is Mike Nixon. I live at 79 Lawn Market in Sharpsburg. I'm a former director of information technology research and data analysis for the state of Georgia's parole board, and the director of information technology and education for Georgia Public Broadcasting. I spent the last 2.5 years researching information and reported anomalies related to elections held across the country. I spoke to you last commission meeting about identified and unfixed errors in our elections equipment, namely the Williamson errors, that have been associated with incorrect counting by Dominion machines in Georgia. It's very difficult to be able to share with the Commission and the numerous documented technical flaws of the systems we are using within 3 minutes. What I want you to understand from me is that I and a majority of Americans do not trust the voting process to yield free and fair elections while these machines are being used. When we look back at a time when we didn't question our voting processes, voter registrations and reporting were handled at the county level. Voter validation and tabulation were handled at the precinct level. Transparency and accountability were local and our responsibilities. We did all this via paper and people. So what's changed? Today, voter registration is handled at the state level with a cooperative contract with ERIC, the Electronic Registration Information Center. This is a nationwide organization whose really end result seeks to use state voter data to increase voter registration on a massive scale, while doing very little to clean up election rolls. This non-governmental organization is not subject to open records requests by ordinary citizens. 7 Republican-controlled states have recently removed ERIC from their systems, yet the state of Georgia continues to pay state tax dollars for membership. Voter tabulation is now done by electronically transferring our voter data from this county to the state of Georgia and not done by our county precincts. I'm not aware of anything that we do locally to assure that the ballots that are printed on paper match the machine count done through a proprietary unreadable QR code on the ballot. A federal judge, as you know, has determined that this system is illegal to use in Georgia, but it continues. And then the reporting of our state's election results are done by sending our voting data electronically to an office in Tampa, Florida, owned by a company from Barcelona, Spain. My 30 years of working with computers and the electronic transfer of data proves to me that any of these systems are subject to being compromised. The only way to know an accurate vote total is to hand count paper ballots in our precincts and to not rely on these machines. I request that Coweta County remove machines from the voting process and go back to secure paper ballots. We know how to do it. I ask you to return to a system that we can have faith in again. We have to fix our problems right here in our own county.
Okay, thank you for your
very
time.
much.
Appreciate it.
Next, Mr. Chairman, Paula Plunk.
Hi, my name is Paula. Can you hear me? I feel like this thing is so tall. My name is Paula Plonk. I live at 104 The Boulevard, Noonan 30263. And this is going to be short and sweet. I just wanted to get up to add my voice to those who spoke before me. I would really appreciate it if y'all would go to paper ballots. I have lost faith in our voter system, not just nationally, but statewide and even here locally. And I believe that going to paper ballots could help restore integrity in our voting system. And also at the last meeting, Commissioner McKenzie had requested that the county go back over and figure out where they could cut back. You know, our economy is not good right now. A lot of people are having to cut back and they can't afford a lot of things. And so we need to see where we can cut back. And that $600,000 toward new voting machines and software would be a great place where y'all could cut back and restore some voter integrity. Thank you.
Thank you.
Next, Mr. Chairman, Ed Palmer.
Ed Palmer, 1010 Gray Girls Road in Sonoya. Gentlemen, Mr. Chairman, Commissioners, thank you for listening to us and hearing what we have to say. We have an important message for you, and I'm just one of many who are trying to express this. Can you all hear me on this thing?
Sure. Yeah, we hear you fine. Thanks.
Okay. I rise to support paper ballots, and we're dealing with a trust factor here, as you've heard other people say. 80% of the Republicans don't trust the Dominion machines. 62% of the Democrats don't trust the Dominion voting system either. And so the cost for the Dominion system is significantly more expensive than paper ballots, and we can save a lot of money and use it to hire more sheriff deputies, EMS, and to supply them with the best equipment available. We're in a battle between good and evil. We, like our founding fathers, are taking a stand against the corruption, fraud, and lies of our tyrannical government, excluding you gentlemen, of course. Yahweh has us each here to stand for righteousness, and that's what we intend to do. We citizens are taking the lead setting the direction and pace. We invite each of you to join us in making the difference in the future for our county, state, and America. Let us not cluck with the chickens, but soar with the eagles. Thank you.
Thank you.
Next, Mr. Chairman, Mark Hines.
Gentlemen, hey, thank you. My name is Mark Hines from 780 Carl Williams in Sonoya. I am an air traffic controller. I work in Hampton, Georgia. It's the busiest air traffic facility in the world. If you see the land arrivals lined up down I-85, that's the Hobbit and Gandalf arrivals. I work those. That's my area of specialty. There's probably about 400 air traffic controllers in my building. I'm probably one of the top 10 best guys or girls, air traffic controllers in the building. Top 10. Everybody watching on Facebook, yeah, I said that, top 10. So, given that, I had to make some tough decisions the past couple nights. I've seen some of the busiest traffic I've seen with the weather rolling through. We brought everybody over to that southwest side, and we got them in. So if you saw extra heavy traffic past couple nights over Noonan, that was because of the weather, and I worked that. Another tough decision I had to make in the past 2 years was deciding not to take the COVID vaccine under threat of losing my job. So I'm there 15 plus years, and they told us, do it by this day or you don't work here no more. Out of the 400, there's, I believe, around 20 of us that made our choice. I think everybody in that situation, we've had a tough couple of years, had to make the choice that was right for them and their family. And that's what I did. And that was a very tough choice. I'm here to ask for paper ballots. I feel like that is an easy choice. That's on my side, looking at you gentlemen up there. If you do it, I got your back 100%, 110%. I got a wife, 3 sons. They got to watch me go through all that, and they get to see me do what I do. And I'm just throwing that out there to you guys. That was the toughest thing I ever had to go through. I think paper ballots, hand counted, I believe there's nothing in it for Coweta County to lose. We have nothing to lose and everything to win in that situation. Please add it to the agenda and vote on it, even if it's even if you vote no. Thank you.
Next, Mr. Chairman, Maxwell Britton.
Good evening. My name is Maxwell Britton, 350 Marion Beavers Road, Sharpsburg. Chairman, Commissioners, I'm here today to correct an inaccurate information about the information our county may have received from the Secretary of State about the legal authority the county has to conduct its own elections. The Secretary has intimidated counties by claiming he has the authority to dictate how they conduct election. But the governor, the state election board, and the Secretary admitted in court that they have no such legal election authority over counties. That's Pearson versus Kemp, 11/29/20. The Secretary cites OCGA 21-2-300 for his election equipment authority, but that same statute explains his chosen system violates state law. The voting machines are illegal. The U.S. District Court confirmed this in an October 2020 order. The system is illegal because it does not produce a ballot marked with the elector's choices in a human-readable format. The current QR code voting system is unverifiable to the voter. The U.S. District Court found the Secretary of State office flatly not credible in an August 2019 order. Counties are responsible to produce their election results. The Secretary of State office only accumulates county results for the state. All Georgia counties determine the number of ballot marking devices and scanners they choose to employ with their election servers. OCGA 21.2, 334, and 336 are overriding statutes confirming legal authority for Georgia counties. 334 authorizes election boards to use hand-marked, hand-counted paper ballots if they deem the system impracticable. In today's news, today, an Ohio special election ballot scanners displayed your vote was not counted. They had massive malfunctions today. Sounds like the Williamson error that we heard about in the last meeting and earlier today. Our votes need to count, yet it is so obvious that the systems we're using are not practicable. Although some saw the other week Spalding County Board of Elections vote on the motion to execute hand count using human readable portion of the ballots for all future elections as a step in the right direction, I disagree. There is no audit procedure that can be conducted on the output of ballot marking devices to confirm that the outcome of the contest is correct, in the sense that it reflects that the voters actually did what the voters actually did on the ballot marking devices, saw on the screen, or heard through the audio, unless virtually every voter diligently checks the printout before casting it, and they don't. There is no reason to believe that an accurate tabulation of ballot marking device printouts will show who really won. In closing, I'd like to urge this board to act to protect the voters with legal, verifiable, accurate, and secure voting system for 2024. We have a simple, cost-effective, cost-savings examples at the ready. I urge you to put paper ballots on the agenda in time for the next commission meeting so that there can be a vote. Adopt hand-marked paper ballots.
Thank you, Mr. Maxwell. Appreciate it.
Next, Mr. Chairman, Christopher Campbell.
Wow. All right. Good evening, gentlemen. My name is Christopher Campbell. I live at 393 Genesee Point, and I'm here tonight to discuss code inspections. I've reached out directly to Mr. Blackburn on June 15th seeking his assistance with no reply. I've been in constant communication with Community Development Director John Amison. Homes in Coweta County are passing inspections structurally and environmentally without meeting the minimum regulatory requirements to do so. To shed light on some of these claims, I've used my personal home as example. County records show that my home has passed all required inspections on February 28th of this year. However, in March, following the inspection, combustible materials were found in contact with chimney pipes. The HVAC system had yet to be completed, and when it had been, what had been installed was significantly compressed. On January 9th, 2018, policy was adopted to ensure that before issuing certificate of occupancy on a home, 100% of the soil surface must be uniformly covered in a permanent vegetation with a density of 70% or greater. If not, the permittee shall post a bond in the amount sufficient to provide sod on any area not meeting final stabilization requirements. This picture was taken on February 17th, 10 days before inspection. This one was taken March 9th, 9 days after inspection, still no permanent vegetation growth. Mr. Fouts claims, and I quote, "Our team has consistently strived to uphold the standards set forth by the EPD and this local policy. I beg to defer. Inspectors passed the home without grass or bond requirements because grass is hard to grow in the winter." Here's your words. Mr. Fouts also states that this Board of Commissioners is familiar with what has been said here today and has opted to take no action. I ask that you please reconsider. I thank you for your time, and I yield back.
Thank you. Thank you.
Next, Mr. Chairman, Eric Daugherty.
Ladies and gentlemen, Eric Daugherty. I live at 585 Genesee Point, also in the Genesee neighborhood with Mr. Campbell. Just want to reiterate that what he's saying is true. There are shortfalls across the board, and that I would ask for a review of your inspection team or inspection board, or even invite you out to come look and see what's actually happening out there. I'm a victim. I closed my house in 2021, unbeknownst to these issues that were ongoing. Thanks to Mr. Campbell's insight, many of the neighbors are up in, I won't say up in arms, but there's starting to be a pimple head out there, right? And eventually it's gonna be a Dr. Pimple show, right? I'm trying to help cool those heads off and help them with it, but I need help. I need help from you guys, and I'd ask that please help us in whatever you can do. Thank you.
Thank you.
That's all the signed up speak, Mr. Chairman.
Okay, I thank you, everybody, for your comments this evening. Is there a need to go into executive session?
There is, Mr. Chairman, for purposes of personnel and litigation.
Second.
Any discussion? All in favor? Aye. It carries. Session. Any discussion? All in favor? Aye. Carries unanimous. Call for motion Call for motion to vote on the matter, the affidavit, okay.
Motion to approve.
Second. Any discussion?
Aye.
All in favor?
Aye.
Carries unanimous.
Make a motion on the personnel matter.
Second. Any discussion? I second.
Make a motion on personnel.
And second, any discussion? All in favor? Aye. Carries unanimous. And let's adjourn the meeting. Get a motion.
Motion.
Second.
Any discussion?
Aye.
Hey, everybody out.